we're going to start with the first section of the rules, which is all about the regulation of the legal profession. It's helpful to know that this subsection of the rules makes up 6 to 12% of your total MPRE exam. As we walk through these highly tested and difficult areas of these rules together today, I'm going to continue to point out these percentages to you. The reason for this is because it's very helpful to know where these questions come from. You'll notice as we walk through these rules that not every subsection of these rules are tested equally. Some are much more highly tested than others. So turning to this first subsection here, the regulation of the legal profession, again, this makes up 6 to 12% of your total exam. The first rule that I want to talk about together today is who gets to regulate us as attorneys. And the rule says that a lawyer is going to be subject to regulation by each state where that lawyer is admitted to practice law. And this is regardless of where the lawyer practices or where the conduct occurs. So this means if I'm licensed to practice law in the state of Michigan, as well as the state of Ohio, and let's say I steal my client's money in the state of Michigan, this means that I'm not only subject to regulation in the state of Michigan, where that bad action occurred, that's where I stole my client's money, but I'm also subject to regulation by the state of Ohio. And this is because I'm also licensed to practice law there. The next rule that I want to talk about discusses that we can also be subject to these rules of professional conduct, not only for our law-related services, but for our other services that we provide to our clients. So the rule specifically says that a lawyer is not only subject to these rules of professional conduct for its law-related services, but also with respect to the provision of non-law-related services if those services are provided by that lawyer in circumstances that are not distinct from the lawyer's provision of legal services to its clients, or in other circumstances by an entity controlled by the lawyer individually, or with others if the lawyer fails to take reasonable measures to assure that a person obtaining law-related services knows that the services are not legal services and that the protections of the lawyer-client relationship do not exist. So a good example of this is the situation where a licensed attorney is also, say, a certified public accountant. So under these circumstances, this rule says that if a client comes to you for accounting services and you do not take steps or make it clear that in providing those accounting services that the lawyer-client relationship does not exist between you and that client, then you are also subject to these rules in regards to those accounting services that you provide to that client. It's oftentimes helpful as you're trying to memorize and understand these rules in preparation for the MPRE to try to figure out why these rules actually exist. Many students find it's helpful to think about rationale. It really aids in their memorization and preparation for exams. So the rationale behind this rule is that if you are, say, advertising your legal services as well as, say, accounting services to the public, this burden is being placed on you as the professional to make it clear to any clients or potential clients that come your way to understand that they might not be entering into a lawyer-client relationship with you. Again, the burden is being placed on us or you as the professional to make it clear what type of relationship you have with your clients. And if it isn't clear and you are not taking those steps, then you are subject to these rules for those non-law related services that you provide to your clients. The next rule I want to discuss is turning to admission to the profession. So this rule states that to be admitted to practice law in most states, one needs to attend college and law school, pass the bar, and pass as well character and fitness clearance. The burden of proof is going to be on the applicant to establish that they have good moral character and to cooperate with reasonable investigation by the state. An applicant for admission to the bar or a lawyer in connection with a bar application or in connection with any disciplinary matter shall not do the following. They shall not knowingly make a false statement of material fact, or fail to disclose a fact necessary to correct some sort of misapprehension known by the person to have arisen in this matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority. So let's just stop there and recap. First and foremost, this means that in order to be admitted to the profession in most jurisdictions, you as the applicant have the burden of proof to show that you have good moral character to be admitted to the bar. The rule then goes on to say that you, as an applicant, and any attorney in connection with some sort of application to the admission to the bar, shall not lie. That's kind of obvious, but that's the first point. It then goes on to say that you shall not lie by omission. Specifically, the rule says that you shall not fail to disclose a fact necessary to correct a misapprehension known to have arisen by a person in the matter. This means even if you're, say, not specifically asked a question, but you know that, say, the admissions authority has some sort of misunderstanding or doesn't understand all of the facts in front of them, you as the applicant or any attorney in connection with your application would have an obligation to correct that information or to, say, disclose whatever fact is necessary to be fully transparent in that matter. And then the last portion of this rule says that we shall not fail to knowingly fail to respond to a lawful demand for information from some sort of admissions or disciplinary authority. And this takes us back to the beginning portion of this rule, where we talked about how the burden of proof is going to be on you, the applicant, to establish that you have good moral character to be admitted to the bar and that you're going to cooperate with reasonable investigation into that good moral character and fitness. So this means if you are, say, contacted because the admissions authority needs more information, or if you are an attorney in connection with some sort of bar application and you are contacted for follow-up information, you have an obligation to respond. There are some exceptions to this rule that I would like to touch on. So the first exception says that any information that is confidential does not have to be disclosed. So to give you an example about this, let's say you are applying to the bar. And let's say I am a longtime family friend and I'm an attorney. And you have asked me to write you a letter of recommendation as part of your bar application. This means that if, let's say, the admissions authority contacts me and asks for some follow-up information about you, I would have an obligation to respond to that. However, if I have information about you that is deemed confidential, and by that I mean information that I have learned about you through some sort of representation of you, I do not have to disclose that information. And arguably, if I do, I'm going to be in trouble because I'm supposed to keep confidential information confidential. So let's say I'm a longtime family friend of yours, and let's say in college you get an MIP. And obviously there are legal consequences to that. So you've hired me to represent you in that MIP matter. And let's say I represent you all the way through its completion. Years later, you go to law school and you apply to the bar. And you again ask me, your longtime family friend, to write you a letter of recommendation. And I do so. If the admissions authority contacts me and asks me for information, say, regarding that MIP incident, I cannot and shall not disclose that information because that would be considered confidential since I had represented you in that matter as your attorney. So that's what this exception means. The next exception, just to touch upon, says that any information protected by the Fifth Amendment of the United States Constitution also is an exception here. But a person that's going to rely on their Fifth Amendment protections in response to a question has to do so openly. So this means, if you are an applicant to the bar and they ask you a question and you want to assert your Fifth Amendment protections and not respond, you can do so, but you have to tell them that. Instead of just not responding, you actually have to come out and say that you are relying upon your Fifth Amendment protections. The next rule that I want to discuss is getting to our committee proceedings in denial of admissions. So first and foremost, the rules tell us that an applicant to the bar is entitled to due process in committee proceedings. It then goes on to say that all aspects of past conduct that reflect on honesty or integrity are relevant when the bar admission authorities are examining moral character. This means a conviction of a crime is enough to deny admission of an applicant so long as the crime involves moral turpitude. For instance, some sort of theft crime, maybe it's a perjury crime, something like that. Or if the crime at issue involves violence. Lying on your application is also grounds for denial of admission. Any applicant going through these committee proceedings is, again, not only entitled to due process, but is also entitled to demonstrate rehabilitation. So let's say they are inquiring into some sort of aspect of your past, and you know it does not make you look good, and you are very concerned, say, about your ability to pass and to be admitted to the bar. During these proceedings, you would be entitled to show that you've been rehabilitated. I also like to touch upon the fact that the rule states that if an applicant fails to take an oath to uphold the US Constitution or their state constitution, they may be denied admission. I like to point out this rule because many people think that this rule uses the word must, meaning that they must be denied admission if they fail to take an oath to uphold the US or the state constitution. However, that is incorrect. This rule uses the word may. So if you refuse to take the oath to uphold the state or federal constitution, the jurisdiction in which you are in front of may deny you admission, but they do not have to deny you admission. When it comes to your citizenship and residency, the rules state that a state may not deny an applicant on the basis that they are not a US citizen or resident of the state in which they are applying. These are not grounds to be denied admission on. And then lastly, if someone is denied admission to the bar, they are entitled to judicial review by the highest state court. The next rule that I want to discuss is regulation after being admitted. And more specifically, it's a brief overview of the disciplinary process. So first things first, usually disciplinary proceedings begin when some sort of complaint has been made to the state bar about an attorney. Maybe it is an ex-client or a current client that's upset with their attorney. But again, this whole process starts by someone making a complaint to the state bar or disciplinary authority about an attorney in question. And then from there, I should back up a step. It's good to state that this filing of the complaint about an attorney is considered privileged. This means that an attorney cannot say go after or sue someone for making a complaint about them on the grounds of defamation. That is not allowed. That complaint is protected or privileged. So that's step one, someone makes a complaint. Step two is when that state bar or disciplinary authority basically sorts through the complaints to make a decision as to whether or not the complaint has merit or if it's frivolous. If they believe the complaint is frivolous, this is usually where the process stops, and that's it. If they have reason to believe that there is some sort of merit to the complaint being made, then they move on to the next step, which is usually having some sort of actual hearing. This is when the attorney is obviously notified. They're entitled to show up and to defend themselves. At this point, most attorneys would hire representation to help defend themselves during this proceeding. And this is when the committee is going to either make a decision as to whether or not there has been some sort of rule violation. And if they believe that there has been a rule violation, they're going to decide whether or not they're going to discipline the attorney, and if so, to what extent. So for instance, sometimes it could be to fine the attorney. Other times it could be to disbar that attorney. The next rule that I want to discuss goes back to the very first thing that we discussed together today in this section, which is all about disciplinary authority. So the rule here states that a lawyer is subject to discipline where they are admitted. So let's start there. It says a lawyer admitted to practice in a jurisdiction is subject to the disciplinary authority of that jurisdiction where they are admitted, regardless of where their conduct occurs. This takes us back to that Ohio and Michigan example. So again, if I am licensed to practice law in both states of Ohio and Michigan, and let's say I steal my client's money in Michigan, not only am I subject to discipline in the state of Michigan where that conduct occurred, but also in the state of Ohio because I'm licensed to practice law there. The next part of the rule goes on to say that a lawyer who is not admitted to practice law in a jurisdiction is also subject to the disciplinary authority of that jurisdiction if the lawyer provides or offers to provide any legal services there. So let's say I'm licensed to practice law in Michigan and I decide I want to move to Wisconsin. I go to Wisconsin and I set up an office. Though I am not licensed to practice law there, I start offering legal services to the public. So under this rule, I would be subject to discipline in the state of Wisconsin because even though I am not licensed to practice law there, I'm acting like I am. I have opened up shop and I'm offering services to the public. And then the last part of this rule says that a lawyer may be subject to discipline in more than one jurisdiction for the same course of conduct. So going again back to that Michigan and Ohio and stealing money example, if I steal my client's money in the state of Michigan and I'm licensed to practice law there, Michigan can take action against me. But if I'm also licensed to practice law in Ohio, even though I didn't steal any money from a client in Ohio, Ohio can still take action against me, meaning I might be disciplined twice or multiple times for that one bad action, stealing my client's money. That is permissible. The next rule that I would like to discuss are the effective sanctions in one jurisdiction in regards to another. So the rule states that sister states generally accept the disciplinary action by one state as conclusive proof of misconduct, but they will apply their own sanctions for that misconduct. So let's stop there. Again, turning to that Michigan and Ohio example, if I steal my client's money in Michigan and I'm licensed to practice law in Michigan, let's say Michigan suspends my license for 6 months. If I'm also licensed to practice law in the state of Ohio, under this rule, this means that Ohio is just going to assume that misconduct occurred because Michigan already investigated me and decided that it did happen. So Ohio is just going to take that as conclusive proof that misconduct occurred and then just decide how they want to discipline me. So maybe Ohio also suspends my license there for 6 months, or maybe they only suspend it for 3 months, or maybe worse, maybe they decide to disbar me. But again, that is permissible and their decision to make. The next part of the rule discusses what happens in the federal court system. So the rule states that the fact that a state has disciplined a lawyer is evidence of misconduct in a federal proceeding, but the federal court must make an independent evaluation. So this means, unlike the example I just gave above with Michigan and Ohio, when it comes to federal proceedings, the fact that the state of Michigan has disciplined me for stealing my client's money is evidence that misconduct occurred. However, that federal court or that federal disciplinary committee is going to make their own independent investigation as to the facts and as to the matter to determine whether or not they believe misconduct occurred and what they are going to do about it. The next rule I would like to discuss is a very important one. It outlines what is professional misconduct. So the rule specifically says it is professional misconduct for a lawyer to, one, violate or attempt to violate these rules of professional conduct, to knowingly assist or to induce someone to do so, or to do so through the acts of another. So let's just stop there and give a quick example. This means if you violate the rules here, that's misconduct. Or if you ask your paralegal to violate the rules for you, that's misconduct. Either way, that is and falls squarely within our definition of professional misconduct here. The next part of the rule says it's professional misconduct for a lawyer to commit some sort of criminal act that reflects adversely on that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Offenses involving violence, dishonesty, breaches of trust, or serious interferences with the administration of justice fall into this category. Additionally, a pattern of repeated offenses, even ones of minor significance when considered separately, can indicate indifference to our legal profession. So, to stop here and talk about an example, for instance. Our example says that Larry Lawyer cheats on his income taxes. Even though this is not in connection with his legal practice, he is going to be subject to discipline. Why? Because cheating or falsifying your taxes is a crime, and that specifically falls in the category of a crime regarding honesty or dishonesty for that matter. So that is considered professional misconduct, and Larry the lawyer can be disciplined for that. Additionally, another example that's good to be familiar with follows. It says Attorney Allen was caught driving slightly over the legal limit for intoxication and convicted of driving under the influence. A single offense may not be sufficient to be deemed professional misconduct. However, if the same incident happens more than once, it may result in professional discipline. Why? This is because while one offense, maybe even minor, like driving slightly over the legal limit and being convicted of, say, drunk driving, that is a criminal offense, and it's serious in that regard. But one of those offenses might not be enough to subject an attorney to discipline. But multiple offenses of that nature start to illustrate an indifference to the legal system. And it tends to reflect that you maybe have a problem with, say, alcohol, or you really do not feel that the law applies to you. Either way, you are putting yourself in a position to be disciplined professionally. The next part of this rule says it is professional misconduct for a lawyer to engage in conduct involving dishonesty, deceit, fraud, or misrepresentation. So a good example of this would be, say, cheating on your bar application or cheating on the bar exam. That's all considered professional misconduct. The next part of this rule says that it is professional misconduct to engage in conduct that's prejudicial to the administration of justice. So what does this mean? This means, or an example of this would be a lawyer who, say, is in the course of representation of a client, knowingly manifests by their words or by their conduct bias or prejudice based upon race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status will violate this rule. So again, if you are, say, representing a client and you are arguing a motion in open court and you illustrate some sort of prejudice or bias, that's going to result, or fall, I should say, into the category of professional misconduct here. The next part of this rule says that it is professional misconduct for a lawyer to state or to imply an ability to influence improperly a government agency or official to do or to achieve results by means that violate the rules of professional conduct or other law. So an example of this would be if your supervising attorney says to you, "Don't worry about the motion you have to argue on Friday. Judge Johnston owes us a favor." You might think that's no big deal. Or maybe you've heard attorneys or your supervising attorney say something like this in the past, and they might not think much of it. However, saying something like that implies that that judge is going to decide in your favor because they owe your boss something. And that is improper. And that would fall squarely within our definition of professional misconduct here. And then the last part of this rule says that it is professional misconduct for a lawyer to knowingly assist a judge or judicial officer in conduct that is a violation of their applicable rules of judicial conduct or other law. So as I illustrated at the very beginning of our time together today, I said you are responsible for also knowing the rules of judicial conduct. Those are testable on the MPRE. Well, it is also professional misconduct to help a judge violate their ethical responsibilities. That falls squarely within our definition of professional misconduct as well. The next rule that I would like to discuss is all about our mandatory reporting requirements. So first I want to start with the general language of the rule, and then I want to illustrate to you how I would approach a question that tests this rule. So the rule says, a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate professional authority. If the lawyer does not report the other lawyer, the non-reporting lawyer is going to be subject to discipline. The same rule applies to reporting judges. So let's stop there. The plain language of this rule uses the word knows. I'm pausing here and making such a big deal about this because if you think, say, a question on the MPRE is testing this rule, the very first thing you should be looking for is whether or not the attorney in question has knowledge about another attorney's rule violation. Why? Because the rule specifically states that in order for this mandatory reporting requirement to apply to you, you must know that someone else has committed a rule violation. So this means if you simply suspect that someone violated a rule, you do not have to report them. You must report them if you know they committed a rule violation. But we're not done yet. The next part of the rule says if you know someone has committed a rule violation, and that violation raises a substantial question as to their honesty, trustworthiness, or fitness in other aspects as a lawyer, then you must report them. So this means just because you know someone has committed a rule violation, that does not automatically mean you must report them. Why? Because the rule specifically states that if you know someone has committed a rule violation, the type of rule violation you must report is one that raises that substantial question as to their honesty, trustworthiness, or fitness in other regards. So some examples. Let's say if you and I are coworkers and we work at the same law firm, and one day at lunch, I tell you that I've been double billing one of our clients because I'm trying to hit all my billable hours for the year. Or maybe because I think that this client will never know that they've been double billed. Well, when it comes to whether or not you should report me, let's break this down. If I've told you I've double billed someone, you know that it's happened, so you have knowledge. Now you have to determine whether or not that type of rule violation raises that substantial question as to my honesty, trustworthiness, or fitness as an attorney. And I would say that that's fraud if I've double billed a client. Fraud would fall squarely under our umbrella of those types of rule violations that raise that substantial question as to that attorney's honesty, trustworthiness, or fitness. So I would say yes, you would have to report me under this rule for double billing a client. But what wouldn't fall in this category? Let's say that I'm a solo practitioner, and many of the cases that I take on a contingency fee basis, which we'll be talking all about here in a few sections. Under these rules, contingency fee agreements are permissible in most cases, but they must be in writing. Let's say that I admit to you, a fellow friend who also happens to be an attorney, that I forgot to put one of my clients' contingency fee agreements in writing. And that it took me, say, a month to realize that I have forgotten to put this agreement in writing. And then once I remembered, I called the client in and we had a meeting and we did finally put that fee agreement in writing. Must you report me? Well, to break down this rule, I've admitted to you, my friend, that I I accidentally violated this rule. Meaning if I've admitted it to you, you have knowledge of this rule violation. But must you report me? That's going to depend on whether or not this type of rule violation raises that substantial question as to my honesty, trustworthiness, or fitness. And I would say probably not. The fact that I accidentally forgot to put this type of fee agreement in writing, that as soon as I remembered, I did. And I scheduled that meeting with my client and I fixed my error. I would say that while you have knowledge of that rule violation, that is not necessarily the type of rule violation that you must report under this rule. I also want to talk about the exceptions to this rule. So the first exception says that the rule does not require disclosure of information otherwise protected by the rules of confidentiality. So let's say I'm an attorney and you're an attorney, and I have come to you and hired you to represent me in some sort of disciplinary action against me. Maybe I did something bad. A former client of mine filed a complaint, and there is going to be a committee hearing as to whether or not I should be disciplined and to what extent. Well, let's say you and I had a meeting and I admitted that I did something wrong or that I violated the rules. Well, you would have knowledge, but you cannot report me because you've learned this information about my rule violation within the context of our lawyer-client relationship. And therefore, it's deemed confidential, and you cannot and you shall not report me. The next exception says that any information gained by a lawyer or by a judge while participating in an approved lawyer's assistance program. So unfortunately, our profession is plagued by many professionals with substance abuse problems. So as a result, there are many sort of programs and processes in place for attorneys and judges who struggle with substance abuse. And many other attorneys and judges volunteer their time in these programs. So let's say you're volunteering your time in one of these programs to help out other attorneys who maybe struggle with alcohol abuse. Let's say I'm an attorney who's participating in one of these programs, and I admit that my drinking habits have caused me to commit violations of these rules. Well, you would have knowledge of my rule violations because I've admitted it to you, but you cannot report me. Why? Because you've learned this information while I've been participating in one of these assistance programs. So because you've learned this information in one of these programs, it falls within this exception and you cannot report me. The next rule that I would like to discuss is all about multi-jurisdictional practice. So the rule first says that a lawyer who is not admitted to practice in a jurisdiction shall not establish an office or other systematic and continuous presence in a jurisdiction for the practice of law. Let's just stop there. So this means if you're licensed to practice law in California, you shall not, say, open up an office and hire a bunch of staff in Arizona and hold yourself out to the public as being able to practice law there because you are not licensed there. The next part of this rule says that if you are not admitted to practice in a jurisdiction, you shall not hold out to the public or otherwise represent that you are admitted to practice law in that jurisdiction. So again, do not take out advertisements illustrating that you are licensed to practice in a place you are not, or do not, tell people or hold yourself out or otherwise represent that you can practice law in a place in which you are not licensed. The rule then goes on to state that if you do either one of those two things we just discussed, such as, say, establishing an office or holding yourself out to the public in a place where you are not licensed to practice law, if you are doing any or both of those things, that is deemed to be practicing law without a license, and therefore you would be subject to discipline. The next part of the rule that a lot of people struggle with, which is why I want to cover it, are the 4 instances in which you may practice law in a place in which you are not licensed on a temporary basis. So the rule states that a lawyer admitted to practice law in another United States jurisdiction and not disbarred or suspended from practice in any place may provide legal services on a temporary basis in 4 circumstances. The first circumstances are when, if your services are reasonably related to your practice in a jurisdiction in which you are licensed and admitted to practice law, then temporary practice would be permitted. So a good example of this is also found in the outline. It says that the officers of a multinational corporation survey potential business sites, and they seek the services of their lawyer, who is not licensed to practice law in the jurisdiction in which they are surveying, in assessing the relative merits of each site. The lawyer can help them, despite not being licensed in that place, in assessing the relative merits of each. Why? Because it falls squarely within one of these four instances. Because this type of work and, assessing the merits of each of these sites is related to your practice of law in a place where you are licensed to practice law, you could do this temporarily and not be subject to discipline. The next circumstance in which you can practice temporarily in a place you are not licensed says that if you associate with a lawyer who is admitted to practice in a jurisdiction and actively participates in the matter. So let's say I'm licensed to practice law in Michigan, and a big case came my way that's happening in Ohio. And I'm not licensed to practice law in Ohio. I can take on the case so long as one of my friends in Ohio who are licensed to practice law help me on the case and regularly and actively participate in it. Then I would be able to move forward with that case. The third circumstance in which you can practice law on a temporary basis is when it comes to mediation or arbitration that arises out of your home state practice. So the rule here states that a lawyer may participate in mediation, arbitration, or another alternative resolution proceeding in this or in another jurisdiction if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice law. So let's say I'm representing clients here in Michigan, and one of their matters brings up the opportunity to, say, arbitrate in Ohio. Let's say I'm not licensed to practice law in Ohio. I could handle that arbitration or mediation in Ohio because it's related to the work I do here in Michigan for that client. And then that fourth circumstance in which you can practice law in a place you are not licensed temporarily is when you have special permission by the judge. So this is essentially when you would file a motion in whatever jurisdiction you are hoping to gain permission. And you basically ask that judge for permission to move forward on this case in this place in which you are not licensed to practice law. If the judge gives you permission, then you can. If they don't, well, then obviously you can't. And then the last part of this rule I just want to touch upon to kind of give you the big picture here says that a lawyer who is in good standing and admitted to practice law in a different state or in a foreign jurisdiction may have an office or other systematic and continuous presence in a jurisdiction if they are employed by only one client, for instance, like in-house counsel for a client or some sort of government attorney. But in the event you want to litigate and say represent this client in court, then you would actually have to get special permission to represent them in court. The second circumstance in which you can practice law in a place you are not licensed to practice law or have that kind of continuous and systematic presence in a place in which you are not licensed to practice law is if you are permitted by state or federal law to do so. So for example, if I take the Michigan bar and I'm in good standing here, but I decide to move to California and practice immigration law because immigration is federal, I can do that. I can open up an office in California and offer immigration legal services to people because I am permitted by federal law to do so, even though I am not licensed to practice law in California. The next rule that's quite important is all about money. It's fee divisions with a non-lawyer. So the rule specifically says a lawyer or a law firm shall not share legal fees with a non-lawyer except in 4 circumstances. So the first circumstance is when you have an agreement by a lawyer with the lawyer's firm, their partner, or their associate. They may provide for the payment of money after that lawyer's death to the lawyer's estate or to specified persons. So let's say you and I open up a law firm and we are partners for many, many years. And we have decided that in the event I die, you are going to pay my family some certain sum of money. And in the event you die, I'm going to pay your family some sum of money. While generally we cannot share fees with non-attorneys, we can fulfill this agreement and ethically enter into it because it falls within this exception of being permissible. So even if, say, my family is made up of non-attorneys, to fulfill our agreement once I pass away, you would be allowed to share money with them pursuant to that agreement ethically and not be in violation of this rule. The next circumstance says a lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer may pay the agreed upon purchase price. So again, if you are going to purchase a law practice from, say, an estate of a deceased attorney, you could pay the agreed upon purchase price to that estate, even though the estate is, say, made up of family members who are not attorneys. That is okay. The third circumstance says that lawyers or law firms may include non-lawyer employees in compensation or retirement plan packages, even if that plan is based in whole or in part on a profit-sharing agreement. And this exception just makes sense. All law firms have non-lawyers that work there, and it only makes sense that lawyers and law firms can pay those employees. People do not like to work for free. So this exception basically says that, and it goes on to say that you could even set up some sort of retirement package for your non-lawyer employees that can be based on a profit-sharing agreement, and that is ethically permissible. And the fourth exception says a lawyer may share court-awarded legal fees with a nonprofit organization that employed, retained, or recommended employment for the lawyer in the matter. So let's say a nonprofit hired me to represent them in some legal matter and I won. I could turn around and share the fees with them because it's a carved out exception and I can do so ethically. The next rule that follows is all about partnerships between lawyers and non-lawyers. So the rule says a lawyer shall not form a partnership with a non-lawyer if any of the activities of that partnership consist of the practice of law. So let's say I'm an attorney and let's say you are an accountant and we're best friends and we've decided that we want to enter into a partnership and open up an office where you are going to offer accounting services to our clients and I'm going to offer legal services. This is not allowed under the rules. Why? Because we've just formed a partnership where some of my obligations are going to be practicing law. And this is a problem because you are not an attorney. So that is not okay. However, let's say you are an accountant and I'm a lawyer and an accountant, but I've decided that I do not want to practice law. Well, you and I could create a partnership ethically, so long as I am not practicing law. If we have formed a partnership to simply provide accounting services to the public, then that is completely fine. But the minute I start practicing law within that partnership is when that becomes ethically impermissible. Turning to our next rule, which is all about the responsibilities of partners, managers, supervisors, and subordinate attorneys. So the rule says a partner in a law firm and any lawyer who possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm are following these rules of professional conduct. So for instance, this would mean taking steps to have conflict of interest procedures in place. That way, everyone can rest assured that we are not taking on new clients or obtaining information that would amount to some sort of conflict of interest and therefore cause issues. The next part of this rule is all about the responsibility of supervisory lawyers and partners over attorneys. So this rule says a lawyer that has direct supervisory authority over another lawyer shall make reasonable efforts to ensure that that lawyer is following these rules of professional conduct. And a lawyer shall be responsible for another lawyer's rule violation here if the lawyer orders it or, with knowledge of that specific conduct, ratifies the conduct involved. So let's stop there. This means if I am your boss and I tell you to destroy evidence and you follow my directions, you and I have both just committed rule violations. Turning to the second part of this rule, it says if the lawyer is a partner or has that comparable managerial-like authority in a law firm in which another lawyer practices or has some sort of direct supervisory authority over another lawyer and knows of conduct at a time when its consequences can be avoided or mitigated and fails to take reasonable remedial action, they too have committed a rule violation. So what does this mean? This means if I am your boss again, and let's say one day coming back from lunch, I stop by your desk and I ask you how your discovery assignment is going. and you tell me it's going great and that you've actually destroyed some documents that you know our client did not want to have handed over. And you were amidst and about to destroy more documents to finish the project. I would have an obligation as your supervisor to stop you right then and there and to do whatever was necessary to try to remedy or mitigate the consequences of your actions. And if I don't, then I myself have committed a rule violation. I would have an obligation to take those steps. When it comes to subordinate attorneys, I'd like to touch upon this rule. This says that a new or subordinate attorney is bound by these rules of professional conduct, notwithstanding that the lawyer has acted at the direction of another. This means if your boss tells you to do something that you know is a rule violation, do not do it, because you have an obligation to know and understand these rules. And if you violate these rules, that is your problem, and you are going to be subject to discipline. The next part of this rule says that a subordinate lawyer does not violate these rules of professional conduct if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. So what does this mean? Turning to our example, it says, if there's some sort of question about whether or not a conflict of interest exists and the supervisor reasonably, however, wrongfully concludes that one doesn't exist, the subordinate is going to be protected from disciplinary action. So the whole idea behind this is, as a new attorney, if you are, say, confronted with some sort of problem, and after doing your due diligence, you say turn to your supervisor and ask them for guidance, and they give you some sort of reasonable guidance, and you do not know that their direction or guidance is in fact a rule violation, and you follow their advice, you will not be in trouble. However, if they obviously give you some sort of course of conduct that is a very obvious rule violation, you cannot just follow their direction and try to escape disciplinary liability. That's not going to work. Here, the plain language of the rules uses the words reasonable resolution of arguable question. So this means that it kind of has to be a close call, and the course of action you take must be reasonable in light of the facts. Next, I would like to turn to restrictions on the right to practice. So here this rule says a lawyer shall not participate in offering or in making the following: a partnership, shareholder, operating, employment, or other similar type of agreement that restricts the right of a lawyer to practice after termination of that relationship, except an agreement concerning benefits upon retirement. So stopping there, this means that if I own a law firm and I want to hire you to be a new associate there, I cannot ask you to sign an agreement where you promise to not practice law after you quit my firm. That would not be ethically permissible. And if you kind of think about some real life examples here, this is oftentimes why when, say, a partner of a firm leaves, they often take their clients with them. Maybe they start their own firm, or maybe they join another firm. And this is because they can. It is not permissible for a law firm to restrict a lawyer's right to practice after their employment, unless, of course, it's regarding some sort of retirement benefits. But that's it. The next part of this rule says that lawyers cannot enter into an agreement in which a restriction on that lawyer's right to practice is part of the settlement of a client controversy. So let's say I'm a plaintiff's attorney and you are a defense attorney, and we work in the realm of medical malpractice. And let's say you represent a doctor, and my client is alleging that your client, the doctor, committed medical malpractice. And let's say that I have sued your client multiple times for medical malpractice on behalf of other clients. And let's say your client, the doctor, is very tired of me and my law firm suing him. So he says to you that he's willing to settle this case for whatever my client wants, so long as I promise never to sue him again. You cannot offer that agreement to me, and I cannot agree to those terms. Both of those circumstances would result in a rule violation. You would have to explain that to your client and that you could not make that type of offer to me. Moving on to the last rule I want to talk about in this section, which is all about the sale of a law practice. So this rule says a lawyer or a law firm may sell or purchase a law practice or an area of a law practice, including its goodwill, if all of the following conditions are satisfied. The first condition says that the seller has to cease to engage in the private practice of law or in that area of practice that has been sold in the geographical area in which that practice has been conducted. So just to be clear here, if I say have a firm that handles all types of different matters, so I'm a general practitioner, and let's say my probate portion has just gotten very big and I really do not have the resources to maintain it. So I have agreed to sell you the probate portion of my law firm. This means that I cannot practice that area of law in our geographical area. That's what this requirement is saying. There are some exceptions to this, requiring the seller to cease the practice of law generally or in that area of law. So these exceptions are as follows. The first says that the return to private practice as a result of an unanticipated change in circumstances would not necessarily result in a violation. This example says a lawyer who has sold their private practice to accept an appointment to judicial office does not violate this rule if the lawyer later resumes private practice upon being defeated in a judicial election. The second exception to this first requirement in the sale or purchase of a law practice says that this does not prohibit employment as a lawyer on the staff of a public agency or legal services entity that provides legal services to the poor or as in-house counsel to a business. So just to reiterate or give you an example, if I sell my private practice, I can go work at, say, some sort of legal agency that's, say, offering work to the poor in our community. I can do that without violating this rule. Or I could sell my private practice to go work in-house for, say, a big business. I can do that without violating this portion of the rule. So to purchase or to sell a law practice, just to kind of recap where we're at, you can do so long as you follow these requirements. The first requirement is that the seller must cease to engage in the private practice of law or in that area of its practice in which they sell. The second requirement says that the entire practice or that entire area of a practice is sold to one or more lawyers or firms. This means that lawyers are not permitted to just take the cases that generate substantial fees or that are very lucrative. Instead, they must take all of the cases. The third requirement here is that the seller has to give written notice to each of the seller's clients. This notice must illustrate the fact that there is a proposed sale at hand. It must also talk about the fact that the client has a right to hire new counsel of their choosing and take possession of their file if they wish. And it must also state that the client's consent is going to be presumed and their file is going to be transferred if they do not object within 90 days of receiving this notice. And our fourth and final requirement to ethically sell or purchase a legal practice says that the fees charged to the clients cannot be increased by reason of the sale. This means that if there are fee agreements in place, they must be respected. So that wraps up our first section of our model rules of professional conduct. And we're going to move on to section 2.